Just to introduce myself, I am Dr. Ntina Tzouvala, and I'm a senior lecturer at the ANU College of Law. And before we get started, I want to acknowledge that today I'm joining this seminar from Sydney, which is the unceded lands of the Gadigal people of the Eora Nation, and to acknowledge that sovereignty over these lands has never been lawfully ceded, and that many of us will also be joining from Indigenous country. This is the first seminar in a new series that I will be convening throughout the year at the ANU College of Law. It's called The Politics of International Law. And the idea is that it will run both of these next semester, and it will bring together, we will take advantage of the Zoom format to bring on board cutting edge researchers from all around the world who will be talking basically about what I just said, the politics of international law, so different international legal fields. And we will be asking our participants to approach their questions both from a doctrinal perspective, but perhaps from a broader political, sociological, economic, aesthetic perspective. And the other half of the equation is that, as you know, these seminars will take place in a conversational format, and our guests will always be in conversation with one of our esteemed colleagues from the ANU. Speaking of, I am really delighted to be introducing the speakers for the first seminar, to be introducing two fantastic women who work both in international law and especially in international investment law. Our speaker for today, our first speaker, is Dr. Jin Ho, who is an associate professor at the National University of Singapore. And she is also a founding member of the International Economic Law Collective, what I think is one of the most exciting initiatives in international law, not just international economic law, but international law the last few years. Dr. Ho is a leading authority in matters of state responsibility, international law, and international investment law. Her first monograph in 2018 came out with Cambridge University Press in 2018 and discussed questions of state responsibility for breaches of investment contracts. And I dare say that it was an instant classic in the field. And also Jin is currently co-editing with Dr. Mavluda Satorova an edited volume entitled, very provocatively, Investors International Law, which will come out, I think, shortly with Heart Publishing in 2021. And Jin today will be talking about covert resistance in pursuit of symmetry in international investment law. And she will be doing so with along with Dr. Esmé Shirlow, who is also an associate professor here in the ANU College of Law. And since we were talking about online teaching, she was convening public international law last year. I was tutoring, and she was a fantastic convener. And apart from that, apart from her fantastic teaching that she just received an award for, actually, Esmé is working on the intersections of public international law, dispute settlement, and international investment law. Her book, her first monograph, Judging at the Interface, Deference to State Decision-Making in International Adjudication, actually just came out last month with some startling endorsements, and her work has also featured in some of the leading journals of the discipline, including, I think, a forthcoming piece in the British Yearbook of International Law. And as I think I mentioned already, what I'm really, really interested in this conversation is that both our speakers are, of course, very eminent academics, but at the same time have a grounding, a very firm grounding in the practice of international law, and especially of arbitration. So I'm really, really keen to hear your conversation. So I think on that note, I will open the floor. The idea, just to keep everyone on board, to bring everyone on board, is Dr. Ho will be speaking for approximately 25 to 30 minutes. And this will be followed by a roughly 15-minute long discussion between her and Dr. Shirlow. And then we will open the floor for Q&A from our participants. So on that note, Jean, whenever you're ready.
Oh, fantastic. Thank you so much, Tina, for having me. It's wonderful to be the opening act of a series. I love being the opening act. So I'm so thrilled that Esmé has managed to make time to chair the session, and I really look forward to the conversation that we'll be having together and the conversation that we'll be having with the rest of the participants during the Q&A segment. So because it's a conversational format this time around, I decided not to sort of like give a sort of a, how do you say, a very prepared sort of a presentation. What I'm going to do instead is to really talk about the work and how it came about. And I think from there, there could be a lot of trigger points for questions as well. So that's what I'm going to do. I'm not sure if I'm going to take up to 30 minutes, you know, we'll see. But at the end of the day, I hope everyone gets, well, at least sees where I'm coming from, even if you're not necessarily sold on the work, which Mavluda and I, when we were talking about it, when we were writing it, we're like, I think this book's going to displease a lot of people, but we decided to write it anyway. So here goes. The title of my presentation is, you know, Covert Resistance in the Pursuit of Symmetry. So when we think of international investment law today, for those who are familiar with the field, you will naturally know why we say it's asymmetrical, right? And for those who are not familiar with the field, the reason why international investment law is regarded as asymmetrical is because it's a field governed by a plethora of investment treaties. And these investment treaties confer protections and rights on foreign investors who are not actually parties to the treaty, but they don't seem to impose any obligations on investors. And over time, we have come to see that foreign investment brings, you know, good things and it brings ills to host countries as well. So what do we do about investor misconduct? What do we do with investors who pollute the environment? What do we do with investors who abuse human rights? There doesn't seem to be any answer, a good answer for those sorts of questions. So that's where the asymmetry comes. The ability of investors to enforce rights and protections and obligations of states in international investment law, but the near impossibility, or at least at this stage, it seems as though we, you know, cannot pursue any sort of redress for investor misconduct under international investment law. So, and that's why I think I'm so grateful that Tina thought the title of the book was provocative when we called it Investors International Law, because when you look at it, we would, and without looking at the contents of the book, you would think, oh, this is international law. It's all about the investors. It's for the investors. And that's why it's called Investors International Law. But we wanted to do something very different, right? So we wanted to push back, but not to the extent where we reject the system. And that's why we call it covert resistance. So on the one hand, we're saying, let's try and work with what we have, but at the same time, let's try and bring about substantive change. And that's why we called it Investors International Law, because we are trying to spin it to see if we can use the existing content of international law to deal with investor misconduct and to bring about investor accountability. So the trigger for the book, of course, asymmetry is something that we've been talking about for a long time in the field amongst the international investment law scholars. But the trigger really was the setting up of the UNCITRAL Working Group 3. I think this was back in 2014-15 when they said that they were going to discuss the reform of investor-state dispute settlement. Again, for those who are familiar with the field, you will know that the field is facing a huge legitimacy crisis. And then again, for those who are not familiar with the field, it came about because there was a lot of dissatisfaction over the fact that, you know, arbitral awards were reining states in to the extent that they were seen as an incursion of sovereignty and the right of the states to regulate what to do about, you know, foreign investments within their territory. There was a lot of dissatisfaction as to how these awards came about, the sorts of people who were making these awards, and the general sort of chaotic situation, you know, that investor-state dispute settlement had plunged international investment law into. right? So there was a lot of dissatisfaction with the field, as a result of which, there was a working group. UNCITRAL set up a working group to talk about the reform of investor-state dispute settlement. And on the heels of that initiative, the academic forum, the ISDS academic forum, was established to provide research that could be of assistance to the working group sessions, right? So research that would that could inform the interventions of the member state delegations at UNCITRAL. And for a few years, I think we've seen the research and the papers that have been generated concentrate on procedural reforms, because that seemed to be the direction that the Working Group 3 sessions were going in. So we want to talk about reform, but let's talk about procedural reform. So there were things like, well, the double hatting of arbitrators. That's something that, some countries were unhappy about. So let's talk about double hatting. Let's talk about costs of the proceedings. Let's talk about parallel proceedings. Sure, I mean, these are all, problems, I suppose, with the system, but procedural reform seemed to scratch the surface of the problem. And we thought, well, maybe, right? And I've said this in a previous webinar before, that I understand the constraints of Working Group 3 and consequently the constraints of the forum. Because if the member states, this is the agenda that's agreed on by the member states, the reform is a state-led process. It's very hard to just try and convert it or alter the agenda from the sidelines. You do need the states to buy in to whatever modified agenda you hope that they will adopt. So we have this going on, at UNCITRAL, this big talk on, procedural reform. And it's a very elaborate process. It takes place twice a year, once in New York, once in Vienna. Lots of, state delegations congregate there. Lots of academics congregate there. It's a huge thing. But there are those who say that, well, this whole thing is just a sideshow, right? And these are the people who are extremely critical of the system and how it came about, and who call for its total abolition. In the past, there were fewer voices, that called for the utter rejection of the current system of investor-state dispute settlement. But in recent times, there have been more and more voices added to this call. So as a result of which, you have two groups that seem to be at two ends of the spectrum. One which is very focused on, let's try and move this thing forwards with reform, but we're going to focus on procedural reform. And we have another group that is just so unhappy that no amount of procedural reform is ever going to satisfy them. And they are calling for utter rejection. And my mentor, Professor Sonaraja, is one of those who's always called for the utter rejection of the system. So between these two extremes, when Mavluda and I met first in China in 2015 and then again in Seoul in 2016 at a conference, we were just wondering if a middle ground is possible. Now, I must explain how counterintuitive this is for me, because I'm a woman of extremes, right? I don't do things by halves, it's all or nothing, go big or go home. And to have me occupy the middle ground is just a very odd sensation, but we did try and think about this carefully and say that, look, at the end of the day, we understand why states might be a bit reluctant to, cancel the system, throw the baby out with the bathwater. But at the same time, you have to acknowledge that things got to be done. And perhaps you do need more than procedural reform. So is there room to, well, jiggle with the content of international law, as unsatisfactory as it is, right, to hope for some kind of substantive change without, abolishing the system and constructing a new one? Because that's what the rejectionists want. And I just don't see that happening, not in the near term and not in the long term either. So our project grew out of, dissatisfaction with the scope of the research agenda that the UNCITRAL working group sessions sort of, because of the process, that was the scope that they ended up with. And also the lack of conviction that we were just going to be able to blow everything up. We didn't think there was sufficient buy-in for that. We don't think there will ever be sufficient buy-in for that. And so again, it's very strange how life works sometimes. And well, I did think I had to be a bit more careful with what I say now, but be careful what you wish for or what you complain too much about, because between the time I accepted this very kind invitation from Tina to be a part of this webinar series, this speaker series, and this talk today, I was elected to the steering committee of the ISDS Academic Forum, and now apparently I'm deputy chair and I oversee the research agenda. So there you go, right? If you were so, you didn't think that the research agenda went far enough because it seemed to focus on procedural reform, maybe now is a chance for me to sort of nudge it in a direction of substantive reform. I'm not sure how far we're going to get, because I'm not a tyrant, and this runs, we have to govern by consensus, so it depends on what the rest of the steering committee wants as well. But I definitely hope, right, there is a little bit of room for us to explore substantive change within ISDS. And with that, I also would just like to, sort of add a little rider to this, because there's a lot of talk these days. And I mean, this whole investor-state dispute settlement has been, it's sensationalized by the media. You see lots of very unflattering things, being written about, ISDS. And then you have people who call themselves, I am anti-ISDS. Well, that's not quite correct, because investor-state dispute settlement, if you just look at the term, it's neutral, right? Unless you are someone who says that if there are disputes between investors and states, they should not be settled, then you cannot have a disagreement with the term ISDS. You can disagree with investor-state arbitration taking place under investment treaties, right? And say that that is a huge problem. We should not have investor-state disputes settled in that way. That is fine. But I think anti-ISDS is a misnomer, because unless, like I said, you are saying that any disputes that arise should never be settled in any way, shape, or form, you cannot be anti-ISDS, all right? So I think a lot of the anti-ISDS proponents are really anti-investment treaty arbitration. And that's perfectly fine. That's a position that one is entitled to take. I'm also, over time, I start to lose confidence in the legitimacy of investment treaty arbitration, but I will never call myself an anti-ISDS advocate. You can't be anti-ISDS, otherwise it'll be chaos, because disputes will never get settled. So, like I said, our book tries to straddle the middle ground, right, between procedural reforms, which we feel don't really go very far, and utter rejection of the system, right? And within this middle ground, right, when we talk about substantive change, what was the one thing that struck us? It was really how, investor obligations, investor accountability was understudied, and we also believe underappreciated. And because Mafluda and I presented a paper on corporate, responsibility at the same conference, and that's why we gravitated towards each other. And we settled on this topic of investor obligations. And we thought, hey, you know what? This is something that to date, not that many people have talked about. And we think it's really interesting. So let's try and explore it. And we didn't think of a book at the start. I think our aims were more modest. We just wanted to assemble a panel and maybe speak at a conference, and then see where it takes us. I mean, we neither of us had any big plans for this. But it was really bizarre. And I can say this now because we're getting a book out, that's why they always say people only present their highlight reels. You don't really see them when they're suffering. But now that we've got the book out, we can say how it came about. And it wasn't all smooth sailing, far from it. So when we just wanted to float the idea as a conference, sort of a presentation in a panel, there were so many doors that closed in our faces. We couldn't understand what was going on. So there seemed to be very little interest, very little uptake, for this particular topic. And for about 2 years, right, we were unsuccessful in getting any sort of airing, for this book. And finally, our break came when we threw a symposium proposal at the American Journal of International Law for the Unbound, and they took it. And all of a sudden, we were like, okay, this is making sense. And from there, we decided to have an extended version of what we were talking about in the Unbound Symposium in this book. So the question that we ask in this book really is, does the current content and procedure in international law allow the pursuit of investor accountability for investor misconduct? And the conclusion that the book comes to is a qualified yes. Because while that content exists, while the procedures are there, well, people need to utilize them, all right? And that was really the challenge that we and our contributors faced, which is to take something that's familiar and either look at it with fresh eyes or use it in a way that it hasn't been used before. So repurposing is one way of putting it, repurposing that content for something else. And this is what we try to set out throughout the book. So it was an extremely difficult book to write. And part of the time, Mafluda and I were like, why do we set ourselves such a difficult task? We should have just written a book that just criticizes the system. This is so bad, and from all these different angles, and we would be done, all right? But we decided to go for something which was far more challenging, but ultimately far more satisfying. We also, I think it's important to put it out there that there's always going to be skepticism, right? Every time you suggest substantive change and the ways to bring about substantive change, before that change actually takes place, there will always be skeptics who say that, oh no, it's not going to happen. Right? It's just not going to happen. Well, okay, you come up with something else, but they can't come up with anything else. So for us, we are willing to put our necks on the chopping block together with the rest of our contributors and invite that skepticism and invite that criticism, because I think at the very least, when you have a discourse, it's better than, utter silence, and inactivity. So when we put in the book proposal, our referees were very kind. But they were also very skeptical, saying that, when you talk about repurposing something for something else, I've never seen it happen before. And where's the proof that it's going to happen? So we responded to our referees saying that, there are times when something is new, you don't have proof for it. But on a theoretical level and on a practical level, if it's feasible, then it's worthy enough as a proposal, right? And until there is uptake for it, I can't tell you there's going to be uptake. And I think I wrote in my chapter, I think it depends on the ingenuity and the flair of the people looking at the content and deciding what to do with it. So if you're going to be very conservative and say that I don't want to do anything that no one has done before, then fine, nothing is going to change. But if you're going to be a trailblazer and an innovator, then here are the tools, and let's see how far they can take you. So I think, Mafluda and I, we became really, really good friends after working on this project, because we both feel the same way. We're both a little subversive, but at the same time, we understand constraints, and as a result of which, we're going to try and bring about change without upending the entire system. As to whether we succeed, we don't know, but it's always worth trying. So I'm going to, sort of briefly talk about my chapter, but then I would like to just, introduce the book. I'm not going to go through every chapter in detail, but it's just to give everyone an idea of the many different areas in which substantive change can be brought about. And right now, when we see, discussions on reform of international investment law, a lot of the emphasis is placed on treaties. So let's try and put new provisions in treaties, and that will hopefully, sort of imprint, investor obligations, into international investment law. So let's have some sustainable development provisions. Let's have provisions on investor obligations. And often people will talk about the India model BIT as having, a provision on investor obligations. So there's a lot of, and it's natural, right? Because it's a system that grew from treaties. And if you think, well, there's a problem, we need to fix the problem, you try and go back to the source of the problem, which is treaties, and then you start tweaking the treaties. I think it's an understandable approach, but it really doesn't go far enough, which is why of the 12 chapters we have in the book, only one chapter deals with treaties. The rest don't. So this is also to give you an idea of where we feel, how important treaties are going to be moving forwards in bringing about change. So the first chapter is mine. Deals with opportunities for investor accountability. So I talk about 3 areas, in which you can try to bring about substantive change. So, 2 procedural and 1 substantive. I will return to that shortly. Mavluda's chapter then deals with the foreign investor as a good citizen. So this is the investor obligations to do good chapter. It's about the investor's social responsibility. So it's an excellent chapter as well. Then we have Lorenzo Catulla and Nicola Perrone. Nicola, who has written a brilliant book, right? In International Investment Law Reimagined and the role of indigenous communities. So the two of them have written a chapter on local communities and why it's really important to take local communities into account when you have investment projects or when you have investment disputes. And they also suggest ways in which local communities can be better integrated into the dispute settlement system. And then it's followed by another chapter by Anil Yilmaz-Vastardis, Risk to Rights, and then she turns the paradigm of international law, instead of looking at it through the rights of investors, look at it from the paradigm of risk. It's a fantastic chapter which you really need to read, to appreciate, to unpack. Then the next chapter is on investment treaties, which is written by Prabhash Ranjan. And then we have Banali Chaudhry, who is well known for her work on corporate social responsibility out of UCL. And she writes a great chapter on soft law corporate obligations. So because corporations are a big problem when you think of investor misconduct, all the the Alien Tort Statute claims over the years, have been brought against large, MNCs, your oil companies, which have been operating out of developing states. And they seem to be only bound by soft law obligations. And Barnali explores the extent to which, do these obligations mean something more, right? Do they converge towards something a little bit more binding for companies? And then we have Martin Jarrett, who writes a really interesting chapter on lawful and unlawful responses, because at some point in time, if the state takes measures into its own hands, when is such a measure legal and when is it illegal? So the scope of the ability of states to deal with investor misconduct without falling afoul of international law. So that's a really interesting chapter as well. Tomoko Ishikawa then deals with counterclaims, which is again this is a very traditional topic, but she looks at counterclaims from the very different perspective of parens patriae, and to say that all states should recognize, parens patriae as a doctrine when approaching counterclaims. So hopefully this might bring about a change in mindset in how people view counterclaims, not so much as a subsidiary tool in investment treaties, but one that hopefully takes equal importance as the ability or the initiative of investors to bring claims against host states. And then finally, this is chapter 9. We have Lucas Ruada and Julian Koo. Julian Koo, of course, is a very well-known constitutional law scholar in the US. Lucas Ruada is based out of Utrecht, and the two of them have given us a great chapter on the, holding corporations accountable under the Alien Tort Statute. So they look at international humanitarian law. So that is that chapter there. And then we have Yuri Zurlik, who again has put out a book as well. His monograph is OUP on armed conflict in international investment law. So he writes the investor obligations and armed conflict chapter. So what we wanted to do really in this book was to cover the basis. So you have, social responsibility, right? So that's Mafluda's point. You had local communities. You have the chapter on international humanitarian law. You have the chapter on armed conflict. You have a chapter on investment treaties. You have counterclaims. And then we have a chapter on environmental commitments and obligations. And then finally, we have a chapter on corruption as well. So it tries to be a more broad-based, if you will, right? So we identified the different contributors based on their forte, their specializations. And we got them to write the chapter, telling us how is it possible, and if possible, how do you repurpose international law to enable the easier pursuit of investor accountability. None of these chapters can suggest foolproof ways to do it, right? And I think sometimes when we look at proposals, we always want to know, is it going to work? Is it foolproof? But at this stage, it's very difficult for us to guarantee anything. But what the contributors and Mafluda and myself try to show is that it can be done, right? If you are willing to innovate, if you're willing to be creative, you will find niches here and there, pockets of opportunity, I call them, where you can go into and try and make the best of it. So that's the sort of the outline of the book. And in my chapter, right, as I mentioned, there are two, procedural, types of repurposing and one substantive. So one is multi-partite treaty-based adjudication, where there's a lot of talk about, increasing stakeholder participation in investor-state dispute settlement. But at present, what we have is the ability of third parties to make submission. We haven't really gone to the stage where you can have indigenous communities have standing as litigants, in an investor-state dispute, hearing, but they can. There's the opportunity to participate as a third party, and I explore the extent to which that particular option there, being a third party, can actually enhance the pursuit of investor accountability. I think it's hopeful, right? That I'm hopeful, right? But at the end of the day, the third-party submissions are subject to the discretion of the tribunal. So if they decide that, well, this is going to take up a lot of time, and I have heard anecdotes from colleagues in practice that at times when you bring these other stakeholders in, it has a tendency to greatly lengthen the proceedings, and that would be one reason for the tribunal to deny third-party participation. But when third parties have participated, a light tends to be shown on investor accountability. So that's one way to do it. The other procedural sort of repurposing is the use of sub-regional courts. Again, this is something that's fairly new, and it hasn't, investor accountability hasn't been sought by a state in a sub-regional court. But I look at the example of the ECOWAS court, and in Africa, and I suggest that that's one way to do it as well. So you don't necessarily have to go through investor-state tribunals and try and tell the College of Arbitrators today, hey guys, you got to do things completely differently. So here's the new rule book. It doesn't work that way. But if you could utilize a different forum for the pursuit of investor accountability, and if it's viable, right? Maybe it hasn't been done before, but it's viable, then maybe it's worth a shot. I understand the constraints there again, because many will say that I'm not going to be the person to bring the test case, but there always has to be a test case. That's why Vedanta is so, there's so much attention on Vedanta, because in a way it is a sort of a test case. So one of these days, the NGOs and their lawyers and whatnot, will see the value in bringing a test case, and maybe another avenue will be open for the pursuit of investor accountability. So the substantive repurposing is that of governing law clauses in investment contracts. So far, I don't think anyone has come up with the argument that it cuts both ways. Because when you have a governing law clause that refers to international law in an investment contract, that contains an arbitration clause as well, you don't have to go for treaty-based arbitration, right? You can just go for arbitration under the contract. And if that governing law clause empowers the tribunal to apply international law, then of course the investor can accuse the state of having violated international law by breaching a contract, which is what a lot of them have done. But conversely, the state could also make a claim that the investor, through its misconduct, has violated international law, since the tribunal is empowered to hear claims which are governed by international law. Like I said before, I don't think this argument has been made, and I don't think it's been done by a state who's been a respondent in an investment contract arbitration, but that option is there. So sometimes we might be so stuck in the mindset, right, that there is this asymmetry that we lose the will to fight it. And we think, well, it just can't be done, right? Because it's asymmetrical. So unless we blow up the whole system, there is no way to get rid of the asymmetry. So the purpose of this book is to suggest that you may not need to resort to something so drastic if you're willing to make some smaller changes in the way in which the law is currently applied. And as to whether that can change the content of the law, sure. I mean, over time, with accretion of practice, you can reshape the appearance of international investment law. So that really is what the project was about, and what the book is about. And like I said, it's covert resistance is never going to be as blindingly effective, I think, as overt resistance. And I think it's not as catchy as overt resistance. But overt resistance meaning you just call for the abolition of the system. But what Mavluda and I strongly feel is that very often when we criticize a system and we don't supply the alternative, or we supply an alternative which has been roundly rejected on many occasions, such as recourse to domestic courts again, right? I mean, that's the reason why we had investment treaty arbitration, because the states took the view that investors didn't necessarily want to settle their disputes in domestic courts. So to go back to that model, at this stage, at this point in time, 2021, it doesn't seem like the most attractive option. All right, and it seems like you're just recycling something that's old, that's been rejected before. So instead of just criticizing and leaving it at that, so blow everything up and then like somebody else can go and clean up the rubble, we decided, okay, why not we try and preserve it, but at the same time we go beyond procedural reforms and see where that actually takes us. So in writing this book, I think we hope to bring about a change in mindset. And it begins with the title, which our referees at heart were also unsure about when they said, can you guys change your title? Because right now it sounds as though you are in favor of investor protection. So this is a book for investor protection. And then when you start reading the contents, you realize, oh, it's kind of not the exact opposite, But we stood firm on that. And we said, there's a reason why we want to call it, Investors International Law, because we want that change in mindset. We don't want you to read it, a title like this, and immediately think it's all about investor protection. It could also be about investor accountability. So we felt rather vindicated once the book was available, the cover was available, and we sort of put it out on social media. And lots of people wrote to us saying that, oh, we love it. It's so subversive and provocative, like what Tina just said. And we're like, exactly, that's what we're going for. So we are very hopeful that with this current very enlightened, academic community that we have, like I said, there are more emerging critical voices out there, which is awesome. And they see where we're coming from and they see where we're going. And at the end of the day, I think it's that's why we write a book. So thank you very much for your time. And I look forward to Esmé's questions. So
thank you. And yes, thank you. That was extremely informative, and I think we're all here looking forward to actually, reading the book. I'll just give the floor to Esmé now.
Right. Well, thank you, Dina, and thank you to CIPL for organising this conversation between Jean and I, and also giving all of us the chance to hear from Jean. I've also had the chance to read some of the chapters from the book, and I have to say it's a really fascinating project, and I think will really fill an important gap in literature around investor responsibility and kind of different ways to rebalance investment arbitration and investment law beyond kind of the tried and tested routes, particularly of counterclaims. So I guess to kind of launch into the questions, I was kind of really interested in this spectrum you were talking about between kind of blowing up the system and then resisting and changing the system from within, and particularly kind of thinking about paths for reform from within, and the interaction between the procedural reforms that seem mostly to be happening, particularly through UNCITRAL's Working Group 3 at the moment, but then also the substantive reforms that some states are participating in and others maybe haven't picked up as much. And I was just interested in your perspective as to how much the internal reforms, so the procedural and the substantive, interact and kind of inform each other and require each other to succeed, and whether you sort of see some of these options within the book as experimentation options for states, or whether you see some of them as really integral to achieving a rebalancing in this area.
I think it's a symbiotic process. So the negotiations at Working Group 3 and whatever it is the academics are doing on the outside, whether as part of the academic forum or in their individual capacity, they ought to feed into each other. So it's important for the member states in Working Group 3 to be aware of how the academics think of the system and what they suggest the improvements might be. And it's also important for the academics to understand the reservations and concerns of the member states so that they can propose something which is more palatable. Now, there's some people who would be quite resistant to this sort of approach and say that, no, I'm an academic. I, have my independence and I'm just going to say whatever I want. And I am not going to fine tune myself, for anyone's sake. But here's the thing, right? I mean, if the states are, some of the main authors of international investment law, of course, that how do you say, when you say that only states are authors, that's not quite correct nowadays, because if arbitral awards are a source of international law as well, then the arbitrators writing the awards are also authors of international law. Academics whose proposals are accepted have a role to play in the shaping of international law. So it's not as simple as states being the ones who put it on paper and everybody else just plays a supporting role. But because it is, at the end of the day, a state-led process. I mean, because they are the ones negotiating the reforms, right? It's not your individual academic name appearing, in the UNCITRAL, member state list. They need to buy into what you're saying. So in order to ensure that there is a very constructive symbiotic relationship, you have to say it in a way that the states are not going to be too turned off by. And at this point in time, total rejection isn't going to work. So when you talk about, in terms of the internal process, the external process, they all have to come together. And I think it's definitely happening, but maybe not as closely enmeshed as I would like, because there's still, I notice, states are conservative, a lot of times you have the officials who are sent there to participate at UNCITRAL Working Group 3. They're not necessarily given a mandate to go and shake things up, on behalf of their governments, right? So go there and attend the sessions and report back, and don't sign on to anything too radical. I mean, that could very well be the instructions that the officials are given. So when they go there, you don't expect people to get up on a soapbox and give a big speech on how the whole system should go and how we should suddenly introduce them. But you don't hear crazy talk like that. It's a very modulated, very moderate process. And so I think the academic forum and academics in general, the scholarly community, they have a role to play in ensuring that the ideas get presented in a way that, as I mentioned, would be more palatable. And as to what reforms would be integral to change, you will need to look at a whole suite of reforms. I'm not saying we throw out procedural reforms. I'm saying we don't just look at procedural reforms. As for substantive reforms, it's got to be something incremental. Basically, try to introduce change without giving the impression that you're asking anyone to change. I mean, that really is the challenge that the academics are going to face. So the more moderate your proposals sound, the more likely there's going to be a lot of the uptake for what you say. So I think it's about it's presentational, right? It's presentational. How you put it across determines how widely accepted it's going to be. At this point in time in Working Group 3, previously they were preoccupied by this idea of a multilateral investment court. I personally am quite skeptical about that, but I take on board that that's something that states are considering. And right now they're very preoccupied with the nuts and bolts of an appellate mechanism. So you see the tendency for the whole of the Working Group 3, right, is to sort of always veer towards procedural changes, because that's the thing that is easier to obtain a consensus on. Just look at the ICSID Convention, right? I mean, it was signed in 1965, and the reason why it's managed to get so many signatories is because it deals purely with procedure. Substantive questions were talked about, but sort of let go, as the negotiations went on, because they just couldn't achieve a consensus on that. So if the objective of the UNCITRAL reform project is to obtain a consensus on something, then I would bet my money that that something is more likely to be procedural than substantive. But what you hope to do, we hope to do as academics or as critical scholars hope to do, is to just plant that seed of doubt at this point in time and make enough states realize that maybe there is a little bit more to this than procedural reforms. There have been a few states that are a little bit more avant-garde, should I say, South Africa being one of them, and some of the Latin American states, but there isn't that critical mass quite yet. And maybe over time there will be, but we just have to keep working in the background, and for the academic forum, sometimes in the foreground, to ensure that that dialogue is maintained.
Do you think, kind of just thinking about the title of the seminar and it being Covert Resistance and the Politics of International Law, and thinking about the kind of moderate change that might be happening through groups like UNCITRAL, do you think that there's a potential or even a risk, depending on your perspective, of some of these tweaks at the margin and tweaks of procedure to dispel the significant resistance that's currently kind of amassed against the regime? And just sort of thinking about your book's title of Investor Obligations and Investors International Law, I'm just wondering if almost kind of creating some of these reform options, if you didn't accept the full plethora of reforms that are being put forward, whether that might actually be one way of saving investor protection and really solidifying an investor's international law.
To be completely honest, the system requires a fundamental rewrite to be able to rid it fully of the ills that plague it today. But when a fundamental rewrite is not an option, or not an option that most states are willing to consider, you have to go piecemeal. And when you go piecemeal, it's almost impossible to say what the risks might be, or what would happen if you simply adopt one reform without the other. My guess is that it will take us in, and maybe a direction which none of us can anticipate. Or some scholars are visionaries in the field. I'm not sure if I'm one of them. Only time will tell. But so there are some who are visionaries. Very, very few though. Very few scholars are visionary in the way that we think of visionaries. As a result of which, it's a guessing game, right? And that's what we're doing. They're doing at UNCITRAL Working Group 3 as well. For instance, if you think, okay, look, investor-state arbitration under treaties is problematic, let's have a multilateral investment court. So that's sort of like it's a very specific, reform to deal with, I guess you could say, sort of a specific set of problems. Is that going to bring any risks? Is that going to bring problems of its own? Some have identified the possible problems with a multilateral investment court. But, the more, so some very practical people will go, well, if that's what the states want, then let's give them what they want, and then we'll deal with the problems as they come. So in terms of the risks involved, there will always be risks, I think, when you make changes. But because, the lack of investor accountability has been so long been entrenched, that any sort of change right now to bring about a little bit more investor accountability is better than no change whatsoever. But if it comes to what I see might happen is, if that sort of reform were to materialize, there will be a lot of pushback from the neoliberal camp. There will be a lot of pushback from the investor community. And that is one thing that states are extremely wary of. So people like Mavluda and myself, the critical scholars who say that, look, things have to change, we need to bring about investor accountability, will always be fighting an uphill battle. There will never come a day, I don't think, where we will go, oh, it's done, let's just sit back and have some biscuits. That day's not going to come. So it's a question of what you set yourself up to do. And it's going to keep going on, because the minute I think we achieve a small measure of success, there's going to be pushback. And then you have to deal with that pushback, and you have to push forward again. So if there is risk, I would imagine this is the risk is that of the field not stabilizing over the years. There's always going to be change. I'm reminded at this stage of Gunther Teubner's seminal article called Legal Irritants. It's in a completely different context, right? Where he talks about how the notion of good faith is understood differently in different legal systems, in the UK and in Germany. And he talks about varieties of capitalism and how that affects the reception of good faith. But here, right, I think the same analogy could apply. So when you throw in a legal irritant, like this pursuit of investor accountability, the system might shake up a bit to try and accommodate this grain of sand, this irritant. But once it stabilizes, something else could come along again, and the internal context will change, the dynamics will change, and as a result of which your investor obligations, having taken sort of like a very grown short roots, might be uprooted again, and then you will have to think of a way to introduce another legal irritant to get the system to shake itself up. And that I think is a never-ending process, So the risk that you mentioned, I see that of the risk of an unstable international investment law.
Do we have time, Dina, for one more question before we open to the floor? Or
I think if you're willing, it depends on whether you two are willing to go a bit after one. If you're willing,
I'm cool. I'm all right here.
Okay, please ask one more question, then we will open to the floor. Thank you.
Okay, final question, which is kind of linked to the last one in a way. One thing I found really interesting in particularly your draft chapter in this book was this idea that a rebalancing of investment law might actually bring and require bringing investment law into interaction with other bodies of law, and particularly domestic law and contractual law and other regimes of international law as well. And so I wondered if one outcome potentially of some of the reforms that you've been discussing today might be to actually position investor-state dispute settlement mechanisms as a useful and legitimate way of responding to disputes that arise in other contexts, kind of beyond the investment treaty or the investment protection statute. And I'm thinking here particularly of potential utility of investor-state dispute settlement procedures for dealing with, say, business and human rights type claims.
I'm a little wary of trying to export ISDS. Because it's currently it's a system that's currently under a lot of stress, right? You have the critics who claim that it's illegitimate. You have the reformers who are trying to reshape it. So until we see what monster we produce, I prefer not to export it just yet. The business and human rights community, I think in recent years, there's been more, how do you say? The word I thought about was inappropriate, so I have to find the correct word. There's more interaction, yes, interaction between the BHR people and the investment people, which is great. But if you notice, the BHR people have set up their own sort of a dispute settlement mechanism, if you will, under the there was a new, the Hague Rules. There's a new BHR sort of a treaty. It's a sort of like a blueprint, it's not an actual treaty. It's a sort of like a model, right? And that has its own self-contained dispute settlement mechanism. So the way I see it, they seem to want to do it on their own and not so much use ISDS, and I think that's fine. But before I think a system or a dispute settlement mechanism can be exported, it has to at least work well enough in its own original context. Otherwise, I would be very wary of kicking the ball to them, and then they realize that this doesn't work and they kick it back to us. So it would be interesting if that were to happen. But my personal view is I would be very wary. And as a critical scholar, it's a bit difficult for me to recommend the exportation of ISDS as is, for the sort of like, you guys could experiment with it too. And because for me, I feel we are maybe not crumbling, but we are definitely struggling here. So we should clean up our house before we invite other people over. So, okay, yeah.
Thank you both. And I think it's a testament basically to Esmé's fantastic questions that basically you have prefigured a few of the questions that we also got. in the chat. So I'll start reading some questions and I'll see how we go for time. Tzouvala is helping you, thanking you, as saying, you know, your presentation is thought-provoking, and they're asking if there's any example of specific investor obligations that you have in mind to be included in an investment treaty. And they're also asking if there are any writings of you on that topic that we are able to access online. So feel free to plug your work here.
Right. I should write a lot more, but I spent the last year, because of COVID, writing blog posts. So I wish I'd written something more substantive. But thank you very much for that sort of that very, very kind words. So I have written, the Age-Old Unbound issue was on investor responsibility. My piece in it was called "The Creation of Elusive Investor Responsibility." So I explain how it is that we come to not talk about investor responsibility. So that is not on investor obligations per se, but it's on how we arrived at this state of not talking about investor obligations. It's only like 6 pages long. So, you know, I think you should definitely, you might want to have a look at that. The next thing I put out on investor obligations is obviously in this book, you know, so if you're minded to, please buy the book. If not, if your library buys the book, then, you know, and if somehow you have problems with it, then please write to me and I will see what I can do. I can send you my chapter or anything like that, you know, so yeah, so do keep in touch on that front. But in terms of what investor obligations I would like to see, in investment treaties, as I mentioned, there have been attempts to introduce investor obligations, and these tend to center around human rights and the environment. Okay, there's some provisions on corporate social responsibility, which you can try and construe as investor obligations, but because CSR is voluntary, right? To be a socially responsible corporate entity, it's a voluntary exercise. You know, investment treaties don't impose sanctions if you fail in your CSR obligations, because they just say use your best endeavors, right? And that's it, and then nothing happens to you. So when we talk about investor obligations, my preference, of course, is to see a full suite of investor obligations, human rights and environmental conservation being two of the most important. But because I'm Singaporean, right? It's very difficult for us to accept a situation where there are like no carrots and, for this situation, no sticks. So in order to enforce investor obligations, there've got to be sanctions. So my concern has always been, how do you enforce those obligations, right? It's not good enough for me if it's in skywriting. You know, we need to be able to bring a claim. We need to be able to seek redress for the victims of investor misconduct, should that misconduct really come to pass. So anything, if you can put it in a treaty, you can introduce sanctions in a treaty, and none of the treaties do that at this point in time, then that would be great. If not, and my suggestion, which is why I wrote the chapter, is that you might have to utilize alternative forums. So you can't do it via investment treaty arbitration. You might have to go to regional courts. You can maybe try and do it via investment contract arbitration, or you try and raise the issue of investor accountability as a third party in investment treaty arbitration. So those are various ways in which to do it. My objective is always to try and seek that concrete sanction. So whilst the content of the obligation is very important, I'm also extremely preoccupied by how we can enforce. So enforcement is a big thing for me, and maybe Mahfouda and I will write the next book on enforcement.
Fantastic. Actually, I'll plug in a question that is very relevant to that by Raj Tripathi. Hopefully I'm not slaughtering the name. And the question is, where do you locate the responsibilities and obligations of transnational corporations, not just in the investment law regime, but international law as a whole, especially when they operate in the vacuum, and by that they mean not being recognized as having international legal personality? So the problem is the question of the corporation in international legal order.
Yeah, I imagine that this is something that Tina would be extremely familiar with, as a lot of people nowadays as well. We understand that international law is biased from the get-go because it was developed for the protection of corporations. So to use international law now to fight corporations might seem like a very counterintuitive thing to do. And that is why we have this book where we try to locate the obligations in other subfields of international law. For example, international environmental law and so on. It's not true to say that they don't have legal personality in international law. If corporations can sue as claimants, then they certainly have legal personality. The question is, can they be respondents? And I would imagine, yes, there's nothing to prevent them from being respondents. If you can sue, you can also be sued. You know, that's the whole essence of legal personality. That's why I said we're always fighting an uphill task, right? In terms of where we locate the obligations that would bind corporations and how we enforce those obligations against them. There is a lot of work to be done in that area, I must admit, because in the past, very few writings have tried to scope out where the obligations are. Our book makes a first attempt, by no means an exhaustive attempt. So if you'd like to find out, I recommend that you procure a copy of the book, and then hopefully it will give you some preliminary answers. Okay, definitely not final answers, but preliminary answers.
Fantastic. And I think I'll ask a last one question from the audience before we wrap up. That comes from Katarina Lundell. And the question is, what role do you envision for domestic investor obligations in bringing about enhanced investor responsibility at the international level? For example, through treaty provisions that require adherence to domestic law?
Yeah, that's a really great question. I think it's hopefully a trend which will pick up. And this is something that investment lawyers will only know about if you sort of, try to integrate yourself with the BHR community, which I tried to do 2 years ago. Then I think I attended my very first BHR conference, and I think it might be my last because I said some weird things and then they got upset. But anyways, it depends on the country, right? So domestic investor obligations definitely can be a way to enhance knowledge and awareness of the importance of investor obligations worldwide. So in a way, it starts at home. But whether domestic investor obligations receive that sort of attention and that sort of a legislative mandate, right? It does depend on the country. One country which has done very well in this regard is Thailand. It's not a country that's discussed very much by international investment law scholars, because it's not a country that's often a respondent state, so it doesn't receive as much attention. Also, because, in Thailand, most of the stuff is in Thai, so it's prohibitive in that sense. Very few scholars are able to research on Thailand if you don't speak Thai. And if you're not Thai, it's the chances of you knowing how to read Thai and speak is close to zero, all right? So it's a country that hasn't really received as much attention. But from what I understand, they definitely have a genuine game plan when it comes to setting out clearly what domestic investor obligations are. And in that regard, they take their business and human rights, corporate social responsibility commitments very seriously, at least on the legislative front. So as much as Thailand is going through a period, of political instability, where they are at with domestic investor obligations seems to be where I hope a lot of countries will be at some point in time. So when you talk, this would be a sort of a bottom-up approach in terms of, making sure that investors behave, is to start at home. I think we need more states that will, sort of follow Thailand's example. And that example, I think, needs to be broadcast way more widely than it is right now. So there are always examples out there to follow. There are always models to emulate. And whilst you may not necessarily want to emulate everything about Thailand, I think this is the one aspect where they have demonstrated a genuine commitment to betterment. So I'm fully supportive of trying to ensure that domestic investor obligations are taken seriously, but that depends on the state. But when you have states like Thailand who really put their money where their mouth is, right? At least, like I said, on the legislative front, that's a good first step. That's a good first step, and certainly one which I hope a lot of other states will follow.
Fantastic. There is more questions at the audience, but I think I'll stop before we all get very tired and before we exploit the kindness of both Jean and Esmé. I want to thank you both for what was, we could not have had a better opening seminar. Thank you both very much, and thanks to everyone for attending. And just, a very quick plug in here that the next seminar is going to actually be in 2 weeks' time when Professor Lucas Lesinski is going to be talking about his new book, Legalized Identities, together with Professor Laura Jane Smith from the ANU. Thank you all very much. Thank you to Ashley, our administrator, without whom none of this would have happened. And we are all looking forward to the book. I think I'm speaking on behalf of everyone to say that, it will be, it is already causing some enthusiasm, and we're all looking forward.
So happy to hear that. Thank you very much for having me.
Have a good day. Thank you. Thank you.
Have a good day. Have a good weekend, everyone.
Bye.